Good morning to all of you. Welcome to Legal Matters by Statebof Madhya. Today, we are going to discuss a beautiful judgment given by the Honorable High Court of Madhya Pradesh, in which it was opined that a man was wrongly convicted and he was in jail for 13 years. And therefore, the state has to pay 42 lakhs as compensation. This is one part. The man is at liberty to file a case of malicious prosecution under tort law against the state for any amount of compensation, because law of torts, tort is a civil wrong which is not a breach of trust or breach of contract, and where the injury is done, then the legal remedy will be by way of compensation in the shape of unliquidated damages. So here the important point is, a man was unnecessarily wrongly convicted. So this is the important part. Now, while disposing the case of Chandresh Manskole versus State of Madhya Pradesh in Criminal Appeal number 1580-1580 by 2009 on 4th May 2022. So Honorable Justice Atul Sridharan and Madam Sunita Yadav, they held that the accused, that is Chandresh Manskole or appellant, he was wrongly convicted and he was in jail for 13 years. At the age of maybe 23 or so, he has gone to the jail, and now still he is in jail. Now his age is 36 years. Now, who is responsible for this? What is the vicarious liability? So, the state is liable to pay 42 lakhs as compensation, and they may recover from the police department or any other agency concerned. Beautiful judgment by Madhya Pradesh High Court, Jabalpur bench. Now, we will go to the facts of the case. The appellant, this is Chandresh Manskole, he was studying 4th year MBBS at the time of offence. The offence took place, he was arrested in 2008, I believe. The offence took place on 25/9/2008, and he was arrested immediately. He was a student of 4th year MBBS at that time. He was a scheduled tribe person. He was goaned by caste. Normally in Adilabad area, other things, we will be finding this Komram Bhim, goans. So he is a goaned by community. Of course, his caste is in no way relevant to this case, but just for interest sake and to say that they are poor people and they cannot meet out to the justice, for that purpose only I am telling the caste. Otherwise there is no necessity to mention the caste. Of course, this was mentioned in the judgment, not me. Right. Now, as per the prosecution, the prosecution's theory goes like this. The appellant killed his fiancée, just like our very famous O.J. Simpson case. He killed his fiancée, then he has actually taken the car of his friend, that is Hemant. He has borrowed the car of his friend Hemant, in which he took the wrapped dead body inside, put it inside the dicky, and went to a long distance place and threw it into a ravine. Right? It is near Panchmadi or Panchmari they call. So, with the help of the driver and with the help of the so-called, with the aid and abetment of that Hemant. So, this is the thing. This is the prosecution story. ప్రాసిక్యూషన్ స్టోరీ ఏంటంటే, మనవాడు డాక్టర్గా ఉన్నప్పుడు తన యొక్క ఫియాన్సీని, లవర్ని అనుకుందాం, ఆవిడని చంపేసి హేమంత్ అనే ఫ్రెండ్ యొక్క ఆవిడని బాడీ అంతా ఒక గుడ్డలో ర్యాప్ చేసి సూట్ కేసులో పెడతారు కదా. ఆ తర్వాత ఫ్రెండ్ హేమంత్ అనేవాడు కారు తీసుకుని ఆ కారు డిక్కీలో ఈ బాడీని పెట్టి హేమంత్ డ్రైవరు ఇతను కలిసి ఆ బాడీని పంచ్మడి నదిలో ఉన్నటువంటి చిన్న రబైన్ దాంట్లో పడేశారు. మన గుండ్ల కమ్మలాగా దాంట్లో పడేశారు. దిస్ ఈజ్ అ స్టోరీ. Then the body was recovered, post-mortem was done, viscera was seized, blood-stained clothes were seized, all these things, the routine inquiry and investigation was done. So this man was arrested basing on the evidence available as per the version of the police. So What is the evidence? Evidence is Hemant. Hemant said that this man asked for his car, he has given him. Driver said, I have followed him. This man went near Panchmadi, then he has lifted the suitcase and threw it, or wrapped the body and threw it inside. Right. So already the circumstantial evidence is 100% allowed, and therefore he was convicted for life by the additional judge or by the local sessions judge. This is the story. Then he appealed to the High Court. Now the matter has come to the High Court. So High Court has gone through the entire record. So they have found discrepancies in the evidence of the toll gate person. This is the important point. When the vehicle was going through the toll gate, then the toll gate person normally మీకు తెలుసు కదా, స్లిప్లు ఇచ్చేవారు ఆ కాలంలో. 2008గా జరిగింది, స్లిప్లు ఇచ్చేవాడు. అక్కడ ఆ టోల్ గేట్ డ్రైవర్ని ఎగ్జామిన్ చేస్తే అతను చెప్పింది ఇన్ ద కార్ హీ ఫౌండ్ 4 persons. ఇప్పటిదాకా థియరీ ఏంటి? Our appellant Chandresh Manskole and the driver of that Hemant, both of them were present in the car. That's all. But here 4 persons were found. This evidence were there right in the beginning, but the ADJ court discarded the same. They did not take a serious issue as of this. And second, no doubt the additional judge court believed the presence of the blood on the human blood on the dead body as well as in the car also. Actually, when the toll gate person said like that, the judge would have asked further probe into the matter, but it was not done. As regards the bloodstains also, human blood may be that of the accused person, may be of any person. It is not established that the blood belongs to either the deceased or the accused person. So discrepancies are there. Now the High Court has rejected the claim of the prosecution story. Now they have commented. I will read out. So number 1, there is a delay of seizing the vehicle. After 15 days only the vehicle was seized. Then definitely the blood of the accused definitely might have been found. So it has been placed on the vehicle. Definitely there is a chance of tampering. Number 2, the investigation should not be witch hunt, that is chasing over the accused, but to unravel the truth. That's why I have been telling a number of times that the goal of investigation is reaching the truth. So please remember, here the court opined that police was outright partisan because the appellant said at that particular time he was a student. Number 2, there was a rivalry between Hemant, the group of Hemant and the appellant. Then in such circumstances, how can he take the vehicle of the car of Hemant? Totally absurd. Because students, young blood, normally if that is the case, normally they don't approach one another. So it is highly absurd. So the enthusiasm by the police in a tearing hurry. So they wanted to see that the accused are arrested. When the people said, okay, this man has done it, that's all. They have simply investigated on that line and made him as accused, which is not correct. The real accused is Hemant. The real accused Hemant and he is the driver, not this man. So now what to do? The Honorable High Court released him forthwith and asked the state to pay compensation of 40 lakhs, 42 lakhs. And now the court has given liberty to him to proceed against the state for an action of tort for malicious prosecution. So this is important issue, right? So falsely implicated. What is malicious prosecution? Now the law of tort students, please give careful and please read my notes in page number 56. Malicious prosecution. The essentials. The suit should be instituted by the defendant. Here the case is instituted by the state. Then without any reasonable and probable cause. This is more important. Then maliciously to gain some advantage. What is this? They might have been influenced by Hemant and they wanted to make this man a scapegoat. Then such malicious prosecution was terminated against the defendant and comes in favor of the plaintiff. Now the court acquitted the case against Chandresh Manskole. Yes, it has come in his favor. And now please remember, due to which the plaintiff should have suffered damages, other thing. Here there is a clear mention by the court that they feel that it is a case of malicious prosecution and he can proceed against them. Very good judgment. Please read it. It will be useful for both ways, for criminal as well as the tort law also. Definitely you will be enriched with the legal knowledge. Thank you very much.